There are a lot of elements to consider when preparing and drafting a will. A common misconception is that all your assets that you own and control will form part of your estate and be dealt with in accordance with the terms of your will. This is not the case. For example, assets that you own personally, like your family home, cash in the bank, shares, and your personal belongings, will be dealt with within your will. Although assets held in a family trust, a company, do not form part of your estate. Further, your superannuation entitlements also don't form part of your estate and are dealt with separately again. When we prepare a considered will and estate plan for our clients, we ensure your will is structured and drafted in accordance with your wishes, but also that your companies, family trusts and superannuation are structured in such a way to give full effect to your wishes and to ensure your assets are protected and to pass to who you want at the most appropriate time. As part of our practice, we prepare wills and estate plans for a lot of retirees. During our free initial consultation, most retirees are concerned about asset protection for their beneficiaries. If you have a beneficiary that fits into one of the following categories, you can structure your will and estate plan in such a way to protect their inheritance. That is, we can implement a testamentary trust in your will that will provide your beneficiaries with protection so to quarantine their inheritance so it can be used for its intended purpose and not wasted. The assets that form part of the trust cannot be dispensed to the beneficiaries without the authority of the trustee. So the assets are legally owned by the trustee, which may protect the assets from some of the following circumstances. Beneficiaries who are at risk of divorce or relationship breakdown. If you are concerned a beneficiary's marriage may fail, a testamentary trust may protect the inheritance. That is, if a beneficiary's marriage breaks down and then after they receive an inheritance and the deceased assets are held within a testamentary trust, then it is less likely that they can be subject to the beneficiary's family court property settlement. If, on the other hand, the beneficiary had inherited the assets absolutely or personally, those assets would most likely be taken into account by the family court when making orders regarding the division of the couple's property. Although a testamentary trust offers some protection, depending on who controls the trust and the terms of the trust and who the beneficiaries are, may be taken into account by the family court when considering the financial resources of the beneficiary. Beneficiaries with dependency issues. If the beneficiaries have, for example, alcohol or drug dependency issues, and you are concerned their inheritance would be wasted if they received a lump sum amount, you can hold the beneficiary's entitlements on a testamentary trust, and the trustees of the trust decide when and how much money the beneficiary should receive, depending on their current circumstances. Creditors and bankruptcies. No discretionary beneficiary has a legal interest in the assets of the trust. Therefore, if a beneficiary is at risk of bankruptcy or is bankrupt, the assets of the trust cannot be taken from the beneficiary, so the inheritance is maintained as they do not own the assets themselves. High-risk beneficiaries. If an intended beneficiary is in a high-risk profession business where negligence claims are likely, a testamentary trust will protect the inheritance. Spendthrift beneficiaries. A testamentary trust can avoid the possibility of a beneficiary spending or wasting their share of the inheritance irresponsibly, as the trustees can monitor how and what benefit and when they are given that benefit. Challenging a will. If money is left to a beneficiary on trust and that beneficiary passes away, and there is a challenge to the deceased beneficiary's will, the assets held on the trust will not form part of the estate and therefore be available for distribution. Everyone's personal and financial circumstances are different, so the way that we structure everyone's will and estate plan will also be different. To discuss how to best structure your will and estate plan to maximise asset protection, please contact us today for a free initial consultation. Thank you.